how we have to do it, and what will be the implication of those that law on an individual and organization. And I know there are a lot of questions like that, and for that we have this webinar today to talk about the Data Privacy Act in India, what is being said, and what is going to happen in future. At the end of this presentation and the webinar, we will give you an opportunity to ask your questions, and we would like to ask those questions to our guest. But before we kick off our webinar, as usual, we have a ritual that we would like our audience to have a very short video on HR Success Talk. So I'm sharing the video with all of you, and after that, we will be coming back and joining on our webinar that is on Data Privacy Act in India. So stay tuned. Let's have the video and then we'll join back.
HR Success Talk has started its journey in 2012 with a vision to bring HR and business leaders together in a form of a community to share knowledge and learn from each other. Starting from a single blog, we reached our first initiative called Forum to give a bigger platform to HR professionals to collaborate with each other. Later, we realized that we need to connect our members in person along with online. Hence, we launched our vertical called HR Sting Meets, under which we organize HR conferences and meetups where we invite HR and business leaders to talk about best practices in HR and business in different industries. HR Sting Meets also became a platform for our members to network with each other. We continued and also launched our online assessment vertical, which helps professionals at different levels in their career to learn and get a certificate in a specified field in HR. These assessments and certifications help HR professionals to find jobs or advancement in their career. HR Success Talk has leveraged technology while building the community. Our YouTube channel is focused on providing online videos or diverse different topics for benefits of our members. We can find video study material on topics like talent acquisition, HR generalist, HR analytics, learning and development, labor laws, and many more. During pandemic, we launched our webinar vertical. Again, with the use of the technology, we continued our mission of sharing and learning from each other. We touched thousands of lives across the globe and shared knowledge which was meaningful for our members. In HR Success Talk, we believe in recognizing and appreciating the contribution of HR and business leaders in their field, which is equally important. Hence, we launched our award vertical to provide a platform to professionals to give an opportunity to showcase their contribution and get recognized for it. We believe in fairness and capability. Hence, our jury and selection process is built in such a way that it provides opportunity to those who really deserve it. HR Success Talk has a very good presence on multiple social media platforms and other communication channels like Facebook, LinkedIn, Instagram, WhatsApp, and Twitter. You can also visit our website www.hrsuccesstalk.com to read some interesting blogs by our HR bloggers on trending topics and issues. We are a huge community with global presence in multiple countries and thousands members and growing every month. We provide a platform to our members where they can learn from each other, can share the knowledge, and knowledge for others' benefit, build relationships and networking, and leverage this networking in any way they feel like. We have so many stories where our volunteers have leveraged this platform to find jobs, get new business opportunities, find a mentor to guide. It is up to them how they wish to leverage and use our platform. And guess what? You don't have to pay a fees to be a member or fill any form. You can be a member by click of a button, by liking our Facebook, LinkedIn page, or any other social media channel. Simple, isn't it? You must be wondering how we manage all this. Yes, you guessed it right. We have a force of highly talented volunteers who spend 3 to 5 hours every week of their time for this community. We also invest highly on the development of our volunteers, and our HR team organize exclusive training sessions for them. Some of them have started as volunteers, and today they are playing the leadership role in this community. If you also have the zeal and passion to serve the HR community and time to contribute, you can send your resume at info@hrsuccesstalk.com to be our volunteer. Our talent team will be in touch with you. For us, this is just a beginning. You can either choose to be part of the journey or watch it from a distance. Let's learn and share together.
All right. Thank you very much, everyone, for watching our introduction video. And I'm sure all the audience that has joined and excited to learn more about the Data Protection Act in India. I would like to tell that we have our guest with us, Sakshi, who has been kind enough to accept the invitation to be part of this conversation with us to talk about the Data Privacy Act in India. And Sakshi, if I give a little bit of introduction to our audience here, Sakshi is a commercial lawyer, and she has completed her LLB from Campus Law Center, University of Delhi. She is also an advocate on record with the Supreme Court of India and has more than 13 years of experience. She has practiced and advised across a spectrum of laws. She is a founding partner in Atlantic Law Associates, a full service law firm having its head office in New Delhi. She has advised on complex legal issues concerning Information Technology Act, Cyber Security, Insolvency and Bankruptcy Code, Company Act, Foreign Exchange Management Act, and Arbitration and Conciliation Act, and has been involved in international arbitrations as well. Sakshi is also a member of Supreme Court Bar Association, Delhi High Court Bar Association, and is enrolled as an advocate with the Bar Council of Delhi. Well, I think that's exactly makes you the right person to be on this webinar and talk about the Data Privacy Act. That is something which we are hearing from everywhere, and a lot of people have different kind of questions that are coming in their mind. So, Sakshi, as I was saying, that when I heard about the Data Privacy Act in India, there are a lot of questions that were coming to my mind. Like, first of all, what it is, and you know that there are a lot of such Data Privacy Act that exists, like GDPR in Europe, and many other countries has adopted those acts and laws. The question came to my mind: is it same as the GDPR or any other act we have in other country? How it is different? Is it implemented, or is it going to be implemented? What are the nitty-gritties? How it's going to impact me? And there are so many questions, and I think we are at the right platform today where we're going to talk about this particular act and what are the different aspects towards it. So first of all, thank you very much for accepting this, and we welcome to you on this webinar.
Thank you so much, Govind, for a wonderful introduction. So, we will go through a small presentation that I've prepared that will help us answer the questions that you've just asked. I am hoping that all the questions will be answered. If not, then we'll keep taking questions in order to clarify any doubts that anybody has. If I could just have the presentation,
Yeah,
and I will.
that will be great. So let me just share the presentation with
Sure.
everybody. And what I wanted to tell to our audience is that please keep sharing your input suggestions through chat box. Whether you have joined on LinkedIn, Facebook, YouTube, any platform, please keep sharing your inputs. And if you have questions, do ask them. At the end of this presentation, I would like to take those questions with Sakshi and answer that to you. But I think Sakshi, I agree with you. This is the right approach. Let's go through a deck, and this will give an opportunity for everybody to set the base of this concept, and top of it, we can then ask our questions. So here I'm going to share this presentation with everybody, and feel free to now kick off and take all of us through that.
Sure. So I will start with the name first. As the name itself suggests, it is a Digital Personal Data Protection Act. What is to be protected is the digital personal data. And that is what we have to keep in mind. It's the data, it's personal data, and it's personal data that is available in digital form. That is the government is looking to protect, and that is what this act is looking to protect. This act has already received the assent of the president on 11th of August this year. However, the rules and the manner in which this act is to be implemented are yet to be framed. So it's not implemented as yet. If we could move to the next slide. So let's start with the intent of this act and how is it applicable. See, whenever a new act is implemented or it is sought to be implemented, it's very important to see the intent of the act as to what is to be achieved by that act. And what this act is trying to do is to strike a balance between processing of personal data and the individual right to protect personal data. On one hand, is the right of an organization or anybody else to process a personal data because it is required to perform certain functions. And on the other hand, is the right of an individual, which can be you, me, or anyone, to actually protect my personal data. I would want it to be protected. I would not want it in. That's an option that I have if I don't want it in the public sphere. That is where this balance is sought to be achieved by this act. Now, what is personal data? It is not just personal data, it is digital personal data. It's a data through which an individual can be identified, or in relation to a data wherein a person can be identified, say a name, a mobile number, an Aadhaar number. These are things from which a person or an individual can be identified. Now, where is this act applicable? It is applicable to processing of digital personal data within India, but it's also applicable to processing of data outside India as well, if that processing outside India is for the purpose of offering goods and services to a data principal within India. So in this scenario, if I am the person who's going to receive a service and I'm the one sharing the personal information, then in that case, I am the data principal that the act is referring to. And if certain goods and services are to be provided to me, and for that purpose, the data is being processed in a country outside India, then even in that case, this act would be applicable. Now, if we move to the next slide, it will take us through the stakeholders that are important in this act. First is the data fiduciary. The data fiduciary is basically an entity that determines the purpose for which a data has to be processed. Now, the next is a data processor. A data processor is an entity who processes data on behalf of the data fiduciary. A correlation has to be made. The fiduciary determines the purpose, the processor then processes the data. Now let's take an example because this can be slightly confusing. Let me take Google's example. Say Google collects certain data from you, and in that case, it sends it to a third party in order to process it. In that case, the data fiduciary is Google, the data processor is the third party. However, if Google is the one collecting the data and also processing it, then it's both a data fiduciary as well as a data processor. So an entity can be both or it can be different entities. Now, the next stakeholder in this act would be a data principal. A data principal is an individual whose personal data would be processed. For example, I am the one who will be taking certain services online, say from a pharmacy or anywhere, and I provide my information. In that case, I am the data principal if I'm providing my personal data. Consent managers. Now, consent managers are basically to be appointed by data fiduciaries for ensuring that consent related activities are carried on in the manner in which they are to be carried on as per the act. Then the government will also formulate a data protection board. The data protection board will basically be adjudicating the disputes in relation to the act. Now, there will also be an appellate tribunal. An appellate tribunal will deal with basically the appeals that will go from a data protection board. In this case, the appellate tribunal will be the Telecom Dispute Settlement and Appellate Tribunal. If we could have the next slide, that will be TDSAT. That is where all the appeals will lie. Now, there's another important stakeholder in this is a significant data fiduciary. A significant data fiduciary, we realized what a data fiduciary was, the one who's determining the purpose. Now, there's another term under this act, which is significant data fiduciary. A significant data fiduciary will be notified by the central government. It's still yet to be notified, depending upon the basis of volume, nature of risk to the data principal. There'll be certain other factors also that will be kept in mind in before a significant data fiduciary will be notified. Now let's move on to, since this is a consent driven act, if we could have the next slide, it's the consent of the data principle that is really important. Now there are certain aspects that have been laid down under the act as to how the consent has to be taken. Now, a very, very important aspect that has to be kept in mind is that the consent has to be free, it has to be specific, it has to be informed, it has to be unconditional, and it has to be ambiguous. The consent that a data principal is giving should be for a specific purpose. The data principal should be giving it voluntarily. There should be no coercion while providing the consent. It should be an informed consent. The data principal should know the purpose and the process for which the personal data or the consent is being provided. It should be unconditional. There should not be any conditions on the consent that is being provided. And it should be unambiguous. There should not be any ambiguity in the consent that is being provided. Now, there are certain aspects that a data fiduciary has to keep in mind while a consent is being taken. The data fiduciary has to present the request to the data principal in a clear and plain language, or language that is clear, that is plain, that provides what is needed. Also, all the languages that are provided in the 8th schedule to the constitution, the request by the data fiduciary can be provided in all those languages. That should also be an option. There are a total of 22 languages. That option is really important. Now, also the data fiduciary has to provide the details of the data protection officer who has to be appointed, or any other person who is authorized by the data fiduciary to respond to the communication of the data principal in order to enable the data principal to exercise rights. So when I am collecting consent, or when a data fiduciary is collecting consent, the data protection officer, the role that the officer will play is that that person will be authorized to respond to any communication. In case I, as a data principal, tomorrow, if I take my own example, have to exercise certain rights that are given to me, then in that case, the data protection officer is the person who should be the communicating one. Now, another important aspect of the first thing that consent has to be, it has to be free. A necessary corollary from the fact that consent is free is that the person or the data principal should also have the right to withdraw consent. If I'm giving consent, I should also have the right to withdraw it. And while the data fiduciary is collecting consent or is asking for consent, the data fiduciary also then has to provide an option for the data principal to withdraw that consent. It's very, very important. If we could have the next slide, please. Now, since the act itself is consent driven, is individual driven, if you look at any privacy act, it will always be individual right driven. And in that case, it will always be data principle driven. And therefore, the data principle will have certain rights that are given under the act. The data principal has the right to access information about the manner in which the personal data is being processed. If an individual is providing data, then that individual is entitled to know the manner in which that personal data is being processed, how it will be processed, the process of it. Now, when in the previous slide we talked about that the data principal should have the right to withdraw consent. Now, if a data principal has the right to withdraw consent, then in that case there should also exist a correlating right to correction as well as erasure of personal data. Once the consent is withdrawn, the data principal also has the right to demand that that data be erased from the digital form. It should not then be stored somewhere. The right exists with the data principal to ask for complete erasure, the right to for that data to be forgotten. In addition to that, the data principal also has the right to grievance redressal. If a data fiduciary is collecting information or is collecting personal data, it also has to then provide a grievance redressal mechanism. Tomorrow, if the data principal has any issues with regard to the collection, processing, the consent that was given, withdrawal of consent, or any other right that are provided under this act, the data principal should have a right to grievance redressal, and that's a right that has been provided. In addition to that, and this is important, a data principal also has the right to nominate someone who will act on the data principal's behalf with regard to how the personal data is used once the data principal dies. See, in the digital form, the data obviously will continue in case the consent has not been withdrawn. And therefore, the nomination becomes important because the data principal then nominates someone else who will then be acting on behalf of the data principal insofar as the processing or other acts are concerned. If we could move to the next slide, please. Now, the processing of personal data. The circumstances or the instances where the personal data will be processed or digital. So, let me reiterate again that it's not just personal data. This act is not applicable to offline data. This act is only applicable to data that is available in digital form or which has been digitized. Either personal data that you're providing today or personal data which has been digitized. Now let's look at instances wherein the processing of personal the data is allowed. The first is where consent has been given voluntarily by the data principal, as we've seen. If a data principal is undertaking certain activities or is looking for certain services or is availing certain services and therefore gives consent voluntarily, then in that case, the data will be processed. For the state and any of its instrumentalities to provide certain benefits to the data principal. Okay, so for this, let's take an example. Say, as an individual, a person has to upload certain data in order to get certain subsidies or to get certain benefits. Then in that case, the processing of personal data is allowed because the state is doing it for the benefit of the data principal. The next instance is for fulfilling obligations under the law. If there are certain obligations that can be fulfilled by processing of the personal data, then in that case, that is allowed. For compliance of court orders, if there are certain court orders that require that a personal data or digital personal data be processed, then that is allowed. During medical emergencies and spread of an epidemic, it's allowed. During disasters, it's allowed. Then in that case, it's applicable. Then also for employment purposes and safeguarding the employer from loss or liabilities, it's allowed. If there is certain data that has to be processed in order to safeguard the employer from loss or liabilities. However, I should also point out here that for this aspect, we should wait for the rules and the regulations to come into place in order to understand this part better as to how it will be implemented, how it will be done. Because once the rules come into play, we'll then be able to look at the mechanism for implementation. If I could have the next slide, please. Now, there are certain exemptions wherein this act does not apply, and we will just go through those exemptions once. So, for enforcement of a legal right or claim, this act is not applicable. When the personal data is being processed by any court or tribunal, remember the judicial function. In that, if a judicial function is being fulfilled, then in that case the act allows you an exemption. So therefore it says that for performance of any judicial or quasi judicial function or supervisory or regulatory function, then in that case an exemption is provided. For prevention, detection, investigation, or prosecution of any offense, prosecution of any offense then again is basically a discharge of judicial function, and therefore is an exemption is allowed. Then in that, the next instance is when personal data is of data principals who are not within the territory of India, processed outside India under a contract. In this case, a contract would become really important. If I could have the next slide, please. Now, if there is a merger or an amalgamation that has been approved by a court or a tribunal, or if there is a compromise or if there is an arrangement that is taking place between two companies and the same scheme or amalgamation has been approved by a court or tribunal, then an exemption is provided under this act. Similarly, for ascertaining the financial information of a person who has defaulted in payment to a financial institution, an exemption is provided. So therefore, you have to look at the fact that as far as judicial functions are concerned, as far as regulatory functions are concerned, as far as investigations are concerned, there are exemptions that have been clearly provided under the Act. Now, it is important to also see as to where this Act is not applicable. If we could go back to the first slide, please. Next slide, please. So we will also look at where this act is not applicable. Now we've seen that where the information, the digital personal data is provided, and then it's in that case the act is applicable. Now, say a personal information or personal data has been processed for personal or domestic use, then in that case that act is not applicable. Also, an important aspect to be kept in mind is this: if personal digital data is publicly available and has been made publicly available by a data principal himself or by any other person under a legal obligation to do so, then in that case this act will not be applicable. That applicability has already been exempted. Now, another important aspect that we should be looking at is basically as to the data protection board, because the data protection board is the one that will be settling disputes, or where the disputes will be going. The data protection board has not yet been formulated. Once the data protection board comes into place, then we'll have a better understanding as to the disputes and part of it. Another similarity or another comparison that will happen with this act will be with GDPR, the General Data Protection Regulations. So I think in that case, it's important that we go through certain differences that will exist as far as GDPR and this act is concerned, and mostly so because for a lot of technology-based companies, it will be an important aspect. So under GDPR, there are certain classifications as far as personal data is concerned. It is divided into various subsets. That is not the case under this act. There is no subset. The personal data has been defined under the definitions clause, and that is where it remains. Then GDPR applies to offline data as well, which is a part of a filing system, whereas the current act, the digital personal, does not apply because it's only applicable to digital or digitized data. So Okay, there's a question with regard to penalties. I will take that first before we move forward to this. So the penalty will be depending upon the level of circumvention of the act as well as the level of the breach, and the data principal can also be fined up to 10,000 in case there is a breach of duty on the data principal's part. So one has to understand that it's important that it's not just the data fiduciary or the data processor who can be penalized, it's also the data principal who can be penalized. Also, it's important for me to reiterate again that Section 40 of the Act empowers the central government to make rules, and the rules are yet to be formed, wherein they will provide how the data breach have to be reported, accreditation of the consent manager, and all these aspects will also be taken into account, and the rules are yet to be framed. With regard to the GDPR part, if we go back, then in that case, I have provided certain differences that exist between GDPR and the Digital Personal Data Protection Act. There are certain similarities as well. In both these acts, the anonymized data has been excluded. So, in case the data is not capable of identifying an individual, then in that case, both GDPR and the DPDP is not applicable. Over to you, Govind. We can take certain questions if they're there.
Yep. Thank you very much for setting the base for this conversation, because I think it's important for everybody to have a fundamental understanding of what is that we are seeing and what is that we are expecting. We are getting a lot of comments and a lot of questions right now. There are a lot of questions and comments that is coming to my mind as well, because I am from HR, and this the fraternity HR Success Star is majority of our members are from HR community plus some business leaders. So I'm sure you will hear a lot of questions that are more connected towards the HR as a function. At the same time, we're getting questions which are very generalist. So I'll start with a couple of the questions and
Sure.
that I'm receiving from multiple sources: LinkedIn, Facebook, YouTube, to make sure that we are covering. I'll try to make my I'll try to do my level best to make sure I'm taking all the questions. That's number one. And I like to tell my audience that I would skip questions that are already been answered in this webinar or been asked by somebody else and then we answer it. So to start with, so there is a one question from Mr. Rajinda, and he said, "Is there a requirement of for explicit consent for processing personal data, or can we use privacy notices as in GDPR?"
See, that is why, Govind, I was saying that this is only an act. We will have to wait for the rules to actually specify the manner. What is required right now is that the consent be taken. The manner, or if there is a specific manner that has to be taken into account, will be something. So, the applicability of it or how it will be implemented is where the rules come into play, and that is why this is what rules per se will define as to how the manner or the process that can be adopted.
Awesome. So as I said, I let me begin with some of the question that we are receiving, and also in my mind from my HR fraternity perspective. I know that there are a lot of data which we as an organization, HR as a function, processes in our organization. There are there are employee data available to us, and I love the way you said that it is only applicable for online and digital data and not necessary for offline. And maybe we must have heard it, but I could not I could not kind of got the message very loud and clear, which is very clear to me. If it is offline, that might not fall in that category. It's more for digital one. But now every organization is using HR software nowadays, and we have a lot of data that is available with us from employees. And honestly, India being a country that never kind of gave that much of importance on the privacy of our employees, and we kind of ask every information we want to. How it's going to impact us, like as an organization, and HR as a function, like how it's going to impact us? What do you think about
See, Govind, there is no black and white term to actually answer the question that you're asking. We every law, once it's implemented, goes through its own challenges, and you also have to see how it evolves over a period of time in order to actually come to something that's acceptable. As far as the act per se, in the way that it's been formulated, it says that it's only applicable to digital personal data or any data that has been digitized. And therefore, also an important aspect to be kept in mind is that the consent is being taken for a very specific purpose. If I was to give you an example, say I go to an online pharmacy in order to buy medicines, and the online pharmacy, for the purpose of billing me, asks me for my information and say it's an app that I have downloaded on my phone. It asks me for my mobile number, my name, and everything else, and that is something that is specifically required in order for them to process my order for medicines. However, if that app is also asking for an access to my contacts, and that is
Mm-hmm.
not something that is required for the purpose of this, then my consent is only limited to the fact that I'm giving you personal information only for that specific purpose that you have to fulfill. That is also something that will drive this act moving forward, as in the act, the consent that you've given, how specific is it, for what purpose have you given it. And I believe, as far as HR and employees or organizations are also concerned, moving forward, although there's still some clarity that has to come from the government or from the rules and as it gets implemented. But in effect, if you look at the law, if you look at the intent of the law, they the idea is to keep the consent limited. The idea is to keep the consent specific, and the idea is to ensure that whatever purpose for which the consent has been taken, only that purpose, that information is only utilized for that purpose and not for anything else, which is also the sole basis of how privacy per se has to be protected. Even if we leave the digital world out of it, even in offline world, that is how you intend to protect your privacy, and that is the underlying intent of this act.
Got it. Thank you, Sakshi. I want, this reminds me of a story that I want to share with you, and then I would like to ask, do you think it's going to be the same in India as well? So I visited Europe to meet my team, and they fall under GDPR. And in one of the gathering, we took some pictures, and my team told me that, Govind, please you post these pictures on social media. Make sure that you have consent from everybody on the photograph. That was really weird for me because, of course, in India we didn't had the Data Privacy Act till then. There was no conversation around that. But in Europe and other countries, of course, this is a thing that they take very seriously. Now, with this Data Privacy Act, what do you think? What will happen? Because there are a lot of youngster in India. A lot of people love to have selfies and pictures with their friends, and they would like to post it on social media. So far, we've not been asking for any consent, right? How do we tackle this situation? And do you think this will be a situation with this act that we really need to ask permission from people with whom we are taking picture before posting it on social media?
See, Govind, if I'm being absolutely honest about this, and I even leave the legal part of it slightly on the side, I know that we can't do that because we're discussing on the law itself. There's still time. See, the process of it, the implementation of the law, how it will evolve over the years will take time. And as you're talking, see, if I take your example, the photograph example that you just gave us, it's, look at the intent of it. The intent is to protect someone's privacy. The
Yep.
intent is that it is that you have to take specific consent. The consent that you would have taken from the person who's appearing in those photographs is, do you consent that I put these photographs out on XYZ or any social media platform? So therefore, any privacy law anywhere in the
Mhm.
world will always be consent driven. If I intend to put that information out there, whether I consent to that information to be there, whether I consent for a third party to use that information, how long am I consenting for the third party to use that information? So, say for example, let's take forward the photograph part of it.
Mhm.
You post that photograph online, and it's purely hypothetical and not from an Indian context, but since that it came up in the conversation, let me take it forward. That one person in those photographs consents to it, and say 10 days later contacts you to say, I withdraw my consent. Then in that case, you are duty bound to take down that photograph because
Hmm.
someone has withdrawn their consent. And therefore, we have to look at privacy from the angle that it is individual driven. It's never organization driven. We also have to understand that a lot of compliances will have to be done at the end of organizations. But any act which deals with privacy will always be data driven, will always be individual driven.
Hmm.
And that is why consent forms the basis of this act. Do I consent? Do I not consent? And obviously we have to wait for the rules and regulations and for the manner, or certain, there are obviously certain issues with the act, not with the act itself, but then we need certain clarities which will come with time once the rules come in. uh,
Yeah.
Govind, if I may, there is a question here which says, what happens in case consent is withdrawn by an employee? How do you pay the employee, especially? Well, to answer that question, if consent is withdrawn, then in that case, if you need bank details, salary data, etc., flowing through HR and payroll systems tech, in that case, you will go back to the employee again, specify that this is the limited consent that we need. You have to consent to this. This is the consent that we are asking for. And in that case, if after the process has been completed, it is completely on the employee to withdraw that consent or even ask for erasure of information as this act provides. However, this is at this stage where we see the act. Let's wait for the rules and see if they actually put in a different process to be followed.
Perfect. Sakshi, do you think that that in this law there is a provision to have somebody who is a custodian of data security in an organization? And the way I'm thinking about it is that we are a global organization, and we have data of we are processing data of employees, I'm sure, and there are many other ways by which we are doing it. Is there a condition or provision in the law which is there today, or you foresee, that might ask us to have a person on board, whether external or internal, to look after that particular part of the law?
So this act does provide for data protection officers to be appointed by data significant data fiduciaries. Now, see, understand data fiduciary and significant data fiduciaries are two separate organizations. And it's the significant data fiduciaries who have to appoint the data protection officers. However, there is still some clarity that has to come as to how to decide whether a data protection officer has to be appointed or not. That is something, there is some discussion on that is still going on, but I believe moving forward a data protection officer is the person who will be responsible for the that role in an organization.
Okay, great. um, One other thing which is coming to my mind right now is that, as I was mentioning, that India is a huge country, and in historically we never been very much concerned about data privacy. Like, that's the perception we have. With this act, it's going to be a huge change in the mindset of people. And you given a great example. Like, even if you go to a grocery store, they can ask our mobile number, and we give it without any fear. Like, yeah, you can take a mobile
Correct.
number. That's not a problem. So I don't know how many places my mobile number will be there, and what purposes that has been used. And in past, we have never thought of that in that length. But now, because of this law, I'm sure there will be a lot of education that will go, because the moment it will start getting implemented and people will start getting educating about it, there will be a lot of challenges, questions, process change will start happening. A candid question to you: do you think that this is the law, that's something which can be implemented and enforced in India the way it has happened outside?
Okay, Govind, that's a tricky question. But let me just say that once an act comes into play, obviously it has to be implemented. How efficiently will it be implemented or how it will be implemented is something that we'll have to wait and see. Will there be a need for change in mindset? Absolutely, no two ways about it. The mindset moving forward will have to change once this act comes into force. But see, with everything you need, once when the IT Act came in, if I could, draw a corollary here, when the Information Technology Act came in, there was a lot of discussion as to how it will be implemented, whether it will be effective or not, whether it is something that can be followed. Say, for example, look at digital signatures for signing documents.
Correct.
There was, I'm taking this as an example because it correlates in that space. Once parties started digitally signing documents, in the beginning there was a lot of you know an issue as to whether is it acceptable, is it not acceptable, should we do it, should we not do it. But now everybody knows that it's acceptable. You can digitally sign a document. It's now an acceptable mode. But it has taken its due course. It has taken time for people to adapt to it. And as is with every law, it takes time to adapt. The mindset has to change. There are certain processes that have to be put into place. And I believe it will happen. It will take time, but I guess change is the only constant, and law keeps on changing. And you have to. As the world moves forward, you cannot be left behind.
Yeah, that makes sense. Perfect sense to me. I would like to take one question that is, I think we touched upon it, but a little bit. But let me just still put it on the screen for you. And this question is more about the commercial institutions like banks that we have which are using personal data. So, do they need to? Do they need to take a consent, or they are
So
exempted
they
from
have to
this?
take a consent from how it stands today. Because I did read out exemptions as to the exemptions that are provided under the Act. Banks per se are not exempted. However, in case someone has defaulted, if, as I read out from the exemptions, if someone's defaulted or if there is certain information that is required, then in that case it's exempted. But see, understand, if you're taking personal information, consent is paramount in that sense.
Okay, awesome. Any idea when this? Do you think it will be implemented?
I would not like to be a pundit in that sense. I believe it's here. Let's wait. I mean, once the rules come in, we'll probably have a clearer idea as to when it comes in.
Yeah, because there's so many such laws that come and then we don't see them in light. Do you think that is a possibility as the president has already signed this?
No, I don't think so. I think sooner or later, let me put my money here and say that sooner or later, this law will come into play. Because
Okay.
at some point in time, I believe you also have to stand with the world, and you should.
Okay, great. O- I'll take a couple of more questions before we wrap up. I think this is some the area that we have already spoken about, that what will be the penalties.
See,
One point you mentioned
that's it.
about is
So
that
the penalty will be in continuation with the circumvention that is there. The exact penalties we'll have to see as per the act, or what is the non-compliance per se that is there. But keep in mind that there is another important aspect that you have to keep in mind as far as non-compliance is concerned, that the onus to prove whether consent was taken or not taken is on the data fiduciary. If an issue with regard to non-compliance arises, it will be upon the data fiduciary to prove whether consent was taken or not taken. And depending on that, will the non-compliance be penalized or not penalized?
okay, awesome. So I think these are pretty much the question that we will take, keeping the time in mind,
Also,
and also the.
Govind, if
Go
I
ahead.
may stop you there, the reason I was, not going on to exact penalties is because there is an entire schedule that has been provided under the Act, which defines that if, see, the penalties are completely defined under the schedule. It will lay down what is the non-compliance as well as what is the penalty. And the penalties, I might add, are huge in this case. Say, if I may, if for an example, if I were to read out, it says breach in obligation to give the board or affected data principal notice of a personal data breach may extend to 200 crores. So
Wow.
you have to look at the schedule, but you also have to understand. That's why I've been constantly on the fact that it will always be in correlation to the circumvention that has been done, and therefore what is expected out of the data fiduciary is to be able to prove that consent was taken.
Makes sense. Awesome. And I know that when this particular law comes in forms of rules, when we start having communications around, there will be a lot of work that we need to do. Uh, there are a lot of changes that we need to make in the contract that we have with the employees. I'm not sure. What I know is that there will be an additional work for us as HR as a function. But I'm sure there are many other areas where the additional work will be done. Sakshi, can I ask you, like, if any of our listener would like to come to you and your organization for the support when we have a visibility or the implementation, to seek support to get those rules implemented in the organization in the right way, so that we are covered. Do you think that your organization or your company, Atlantics, provides that support?
See, Govind, as far as information is concerned, obviously we can help, but this will still be confidential under as an advocate. So whoever approaches us, we'll be able to, guide them in the right area.
Awesome. Thank you very much, Sakshi, for being candid, being asking our question, answering our questions. And I know that it is a very initial stage for the law. I know that soon there will be rules, and I know that we will, as an organization, individual, will be more educated about it. Whether it is in our personal life or professional, we have to adopt those changes. I believe it's a step in the right direction. Many countries does it. Privacy of an individual information and data is great. It also comes some nuances with that. Honestly speaking, as it is with all the laws, right? You always have people who will misuse that, and people who will not. But yes, we'll look forward to such more interactions when the rules are there and we have more clarity from the law that what is possible, what is not, and what has been set for a particular condition. I'm sure this will be a great learning for our audience at that point in time. Even this one, where at least we know where we stand, and there are some punchlines which I can see when you are giving the presentation that has registered to my mind, and I think I'm very clear on where do we stand today from this law perspective. So thank you very much, Sakshi, for being here and addressing the HR professionals and business leaders of HR Success.
Thank you so much, Govind. Thank you for the opportunity. And I hope once the rules come in, we can probably have another one in order to explain the manner or the implementation. Because this is still early. And once we move forward and have more clarity as to the implementation, it will help everyone and organizations to put structure in place and processes, which will then help them streamline the entire process of this. And there's one thing that I would like to add in the end, and which is that it will be implemented whenever it's implemented in due course. Once the process is in place, this should be a smooth law. The implementation should not be a problem once you put the process in place.
Makes sense. Perfect. That is awesome conversation, and look forward to have more. I would also like to thank all our audience to who have participated, shared their input, suggestions, and also questions on the chat box. This particular live is in the recorded form on all our social platforms. So if you want to refer or you want to share it with somebody who was looking for some information on Data Privacy Act in India, feel free to share that with them. With that said, signing off. Thank you very much, everyone, for being on the show. And once again, thank you, Sakshi, for all the information you're giving to
Thank you,
us.
Govind. Thank you so much.